Part 5. Offices in the Executive. 1. Vice President and Ministers. Office of Vice President. 108. 1. There is established the Office of Vice President of the Republic of the Gambia. 2. The President shall, within 30 days of assuming office, nominate and appoint the Vice President, subject to confirmation by the National Assembly. Qualifications and disqualifications of Vice President. 109. 1. A person is qualified to be appointed Vice President if he or she has the qualifications required for the election of President under Section 91. 2. The disqualifications outlined in respect of the nomination and election of President under Section 92(1) shall apply to the nomination and appointment of the Vice President with necessary modifications, but the person nominated for appointment of Vice President shall a. Before any confirmation by the National Assembly, produce to the President and the National Assembly a certificate from the authority responsible for the collection of taxes that he or she has paid all taxes due from him or her, and b. not be a member of the National Assembly. Functions of the Vice President. 110. 1. The Vice President shall a. be the principal assistant of the President in discharge of the President's executive functions. b. Act as President during any period when the President is temporarily unable to perform his or her functions, or during any period that the President appoints. c. Answer in the National Assembly questions or other matters affecting the office of President, and shall read on the President's behalf any message sent to the National Assembly by the President. And d. Perform any other functions conferred on him or her by this Constitution or assigned by the President. 2. The Vice President shall not hold any other remunerative office in the public service or the private sector. Vacancy in the office of Vice President. 111. 1. The office of Vice President shall become vacant a. on the death or resignation of the holder of that office, b. on the revocation of the appointment of the person holding that office, c. if the holder of that office assumes the office of President, or d. if the holder of that office, while serving as Vice President, ceases to satisfy any of the qualifications applicable to the office of President. Where the office of Vice President becomes vacant, the President shall appoint a new Vice President in accordance with this Constitution. Revocation of appointment of Vice President. 112. 1. The President may, for any cause, revoke the appointment of the Vice President. 2. Without prejudice to subsection 1, the President shall revoke the appointment of the Vice President if the National Assembly adopts a vote of censure against the Vice President in accordance with Section 120. Appointment of Minister of Government. 1. Subject to subsection 2, the President shall nominate and appoint a. such number of ministers not exceeding 15 to assist with the running of the affairs of state, and b. an Attorney General who shall be a minister and shall be a legal practitioner of not less than 10 years standing. 2. The President shall within 60 days of assuming office nominate and appoint the ministers subject to confirmation by the National Assembly. 3. The President may, whenever he or she considers it fit, reassign a minister. 4. In determining the number of ministers to appoint, the President shall take into account the economic circumstances of the country and the extent to which the economy can effectively sustain the ministries to be headed by the ministers. Qualifications and disqualifications of ministers. 1141. A person is qualified to be appointed a minister if he or she A. is a citizen of the Gambia, B. has attained the age of 21 or more, C. has attained a qualification at tertiary education level and can speak and write the English language well, D. has proven experience of not less than 8 years from the date of earning the qualification mentioned in paragraph C, and D. is of high moral character and proven integrity. 2. A person is not qualified to be appointed a minister if he or she A. is a member of the National Assembly, B. has been declared to be of an unsound mind, C. is adjudged a bankrupt and has not been discharged or has entered into an arrangement with creditors, D. has during any period of service in the public office or in the private sector in the Gambia been found liable of misconduct, misbehavior, negligence, or corruption by a commission of inquiry. E. has during any period of service in public office or in the private sector in the Gambia been terminated or dismissed for dishonesty or immoral conduct. F. has been convicted by a court of competent jurisdiction of 1. an offense involving dishonesty or immoral conduct, or 2. any other offense for which the penalty exceeds 12 months. G. has within 7 years immediately preceding the date of his or her appointment as minister been convicted by a court or tribunal of competent jurisdiction of an offense relating to elections. H. has within 10 years immediately preceding the date of appointment as minister uttered any statement to cause feelings of ill will, disaffection, or hostility between different classes or ethnic groups of the population of the Gambia. I. is found to have made a false declaration of his or her assets by the Anti-Corruption Commission. J. fails to produce a certificate from the authority responsible for the collection of taxes that he or she has paid all taxes due from him or her. Or K. is a serving member of a disciplined force. Vacancy in office and revocation of appointment of minister. 1. The office of minister shall become vacant A. on the death or resignation of the holder of that office, B. on the revocation of appointment of the person holding the office, C. if during his or her tenure any of the disqualifications outlined in section 114 applies or is discovered after his or her appointment. 2. The President may for any cause revoke the appointment of a minister. 3. Without prejudice to subsection 2, the President shall revoke the appointment of a minister if the National Assembly adopts a vote of censure against the minister in accordance with section 120. Functions and incidents of office. 116. 1. The Vice President and ministers shall A. be responsible for such ministries, departments, and other business of the government as the President may assign to them, and B. exercise general direction and control over their respective ministries and departments of government. 2. The President shall, in assigning responsibilities in accordance with subsection 1, have due regard to the competence, experience, and expertise of the Vice President or Minister concerned. 3. The Vice President and each Minister is accountable to the President for the administration of the ministry and departments and other business of government for which he or she has responsibility, and this accountability extends to the National Assembly. 4. The Attorney General shall be the chief legal advisor to the government and shall A. be the leader of the bar. B. Promote, protect, and uphold the rule of law and defend the public interest. C. Have the right of audience in all the courts of the Gambia in respect of civil matters. D. Have authority, with the leave of the court, to appear as a friend of the court in any civil proceedings to which the government is not a party. And E. In the performance of his or her functions, acts in accordance with the dictates of the law. Disclosure obligations of Vice President and Ministers. 117. 1. The Vice President and each Minister shall A. Within 3 months of assuming office, disclose to the Anti-Corruption Commission 1. All assets, liabilities, and business interests he or she has or that is held on his or her behalf, and 2. All the assets, liabilities, and business interests of his or her spouse held by or on behalf of the spouse, and B. Within 3 months of leaving office, disclose to the Anti-Corruption Commission 1. All assets, liabilities, and business interests he or she has incurred or acquired during his or her tenure as Vice President or Minister, or that is held on his or her behalf. And 2. All assets, liabilities, and business interests of his or her spouse held by or on behalf of the spouse during his or her tenure in office. 2. Where upon assuming office, the Vice President or Minister has any business interest, he or she shall, unless he or she otherwise disposes of the business interest, transfer the business interest to be held on his or her behalf in a trust, which shall be managed in a manner to ensure conformity with this section. Restrictions regarding Office of Vice President and Minister. 118. The Vice President and each Minister shall not, during his or her tenure of office, A. Hold any other public or private, and shall not perform remunerative work outside the duties of his or her office. B. Use his or her office or use information entrusted to or received by him or her for personal gain, directly or indirectly, or place himself or herself in a situation where his or her material interests conflict with the duties and responsibilities of his or her office. C. Establish or advocate for, participate in, or promote the establishment, or in any other way engage in the establishment, directly or indirectly, of any organization or institution of a civic, charitable, or other nature. Responsibility of the Vice President and Ministers to the National Assembly. 119. The Vice President and each Minister shall A. Whenever required by the National Assembly, report to the Assembly any matter concerning a ministry or department or other business of government for which he or she has responsibility. B. Be entitled to attend and speak in the National Assembly whenever a bill, motion, or other matter concerning a ministry or department or other business of government for which he or she has responsibility is being introduced or debated. And C. Provide such other assistance as may be necessary to facilitate the National Assembly to discharge its functions and responsibilities. Vote of censure. 121. The National Assembly may, by a resolution supported by the votes of not less than 2/3 of all the members, pass a censure against the Vice President or a Minister on the ground of A. His or her inability to perform the functions of his or her office, B. Abuse of office or violation of a provision of this Constitution, C. His or her misconduct in office, D. Failure to adhere to the oaths he or she has subscribed to on assuming office. Or E. Persistent failure to attend sittings of the National Assembly to answer questions or provide information requested by the National Assembly. 2. A vote of censure shall be initiated by a petition signed by not less than 1/3 of all the members of the National Assembly to the President through the Speaker, stating the ground or grounds on which the petition is initiated. 3. The President shall cause a copy of the petition to be given to the Vice President or Minister, as the case may be, immediately. 4. The motion for the resolution of censure shall not be debated until after the expiry of 14 days from the day the petition is sent to the President. 5. The Minister or Vice President concerned has the right to attend and be heard during the debate on the motion. 6. In this section, misconduct in office means that the person concerned has A. Conducted himself or herself in a manner which brings or is likely to bring his or her office into contempt or disrepute, or B. Dishonestly done any act which is prejudicial or inimical to the economy of the Gambia, or dishonestly omitted to act with similar consequences. 2. The Cabinet. Establishment and composition of Cabinet. 121.1. There is established the Cabinet, which shall comprise the President, the Vice President, and the Ministers. 2. The President, or in his or her absence, the Vice President, shall chair Cabinet meetings. 4. The President may, for the conduct of any particular or general business, invite such public or other officers to attend Cabinet meetings, to answer questions or provide necessary assistance to the Cabinet. Functions of Cabinet. 122.1. The Cabinet shall be responsible for A. Advising the President with respect to policies to be adopted and implemented by the government. B. Advising on appropriate measures for implementing acts of the National Assembly. C. Directing, coordinating, and supervising the activities of government ministries and departments, including state-owned enterprises. D. Initiating bills for submission to the National Assembly and to explain the bills. E. Considering and approving subsidiary legislation for which Cabinet has delegated responsibility. F. Preparing, explaining, and formulating for the National Assembly the budget of the state and its economic programs. G. Advising the President in determining what international agreements are to be signed, ratified, or acceded to, and advising the National Assembly accordingly. And H. Performing such other functions reasonably necessary for the performance of their duties in accordance with this Constitution, or as may be prescribed by an act of the National Assembly or required by the President. 2. Subject to subsection 3, the Cabinet shall, in relation to legislative proposals, make such proposals available in a timely manner to permit sufficient time for canvassing expert and public opinion. 3. Where the exigencies of a legislative proposal do not permit for timely canvassing of expert and public opinion, the Cabinet may proceed with the legislative proposal without such opinion. 4. All Cabinet decisions shall be communicated in writing. Secretary to Cabinet. 123.1. There is established the office of Secretary to Cabinet, which shall be an office in the public service. 2. The President shall nominate and appoint the Secretary to Cabinet, subject to confirmation by the National Assembly. 3. The Secretary to Cabinet shall have responsibility for A. The administration of the Cabinet office. B. Recording and arranging the business and keeping the minutes of the Cabinet, subject to any direction given by the Cabinet. C. Conveying the decisions of the Cabinet to the relevant persons and authorities and, when necessary, to follow up to establish whether the decisions have been acted upon and report back to Cabinet. And D, performing such other functions as may be assigned or directed by the President or the Cabinet. International Relations 124. 1. The President shall be responsible for the conduct of relations with other states and international organizations. 2. The Gambia shall not a. enter into any agreement or engagement with any other country which causes it to lose its sovereignty without the matter first being put to a referendum and passed by a vote of at least 2/3. B. Become a member of any international organization unless the National Assembly is satisfied through a resolution passed by the Assembly that it is in the interest of the Gambia and that membership does not derogate from the country's sovereignty. 3. A treaty entered into by the President pursuant to the powers granted by Section 86(1)(h) (a) is subject to ratification by the National Assembly on a vote of not less than 1/2 of all the members before it has any application to the Gambia, and B. shall not become law unless Section 9(2) is complied with. 4. The National Assembly may a. by resolution establish procedures for the ratification of treaties and other bilateral and multilateral agreements, enact legislation to strengthen the foreign relations of the Gambia, including creating an enabling administrative and management framework through which the Foreign Service of the Gambia will be managed and regulated in a consolidated and coherent manner. 5. The President or any person acting under his or her direction shall not suspend or withdraw the Gambia from any international treaty or organization without the approval of the National Assembly on a vote of not less than 2/3 of all the members. Establishment of Prerogative of Mercy Committee. 125.1. There is established a Prerogative of Mercy Committee whose members shall comprise a. the Attorney General as chairperson, b. the Minister responsible for internal security, and c. 3 other persons not being public officers of wide knowledge and experience and of high moral character and proven integrity nominated by the President. 2. The members of the Prerogative of Mercy Committee shall be appointed by the President after confirmation by the National Assembly. 3. The heads responsible for the administration of prisons and social welfare shall serve as resource persons to the Prerogative of Mercy Committee. 4. The functions of the Prerogative of Mercy Committee are a. to review cases of prisoners referred to the committee by the President to determine whether recommendations should be made in respect of the President's exercise of his or her powers under Section 126 in relation to such prisoners, and b. to advise the President on which cases, if any, referred to the committee merits the President's exercise of his or her power of mercy. 5. The Prerogative of Mercy Committee may, in performing its functions, take into account the views of the victims, or in their absence, the views of their families in respect of the offense for which they are convicted and sentenced to imprisonment. 6. An act of the National Assembly shall provide for the procedure of the Prerogative of Mercy Committee and the criteria it should apply in considering and formulating its advice to the President. Exercise of the power of mercy. 126.1. The President may, on the petition of any person or his or her own prerogative, and after consulting with and considering the advice of the Prerogative of Mercy Committee, a. grant to any person convicted of an offence a pardon, either free or subject to lawful conditions. B. Grant to any person a respite, either indefinite or for a specified period, in relation to a punishment imposed on that person for an offence. C. Substitute a less severe form of punishment for the punishment imposed on a person for an offence. Or D. Remit the whole or any part of a punishment imposed on a person for an offence. 2. The exercise by the President of the power to grant a pardon under subsection 1A shall not extend to a decision of the National Assembly in respect of a President who has been impeached. 3. Where under subsection 1A a person is granted a free pardon, he or she shall be treated as if he or she never committed the offence in respect of which he or she received the free pardon. Or B. A conditional pardon, the pardon remains in effect subject to compliance with the conditions of the pardon. 4. If a person is granted a conditional pardon, the fact of the conviction for which he or she is granted the conditional pardon remains, but that shall not be a bar to the person's full participation in public life. Honours and Awards. 127. 1. There shall be a committee to advise the President on the exercise of his or her powers under this section. 2. The committee shall consist of not less than 3 and not more than 5 persons appointed by the President, subject to confirmation by the National Assembly. 3. The President may, after consulting the committee established under subsection 2, confer honours and awards, including honorary honours and awards, to friends of the Gambia. Other public offices. President's Chief of Staff. 128. 1. There shall be a Chief of Staff to the President, who shall be appointed by the President at his or her sole discretion, and who may similarly be removed by the President. 2. Subject to subsection 1, the term of office of the Chief of Staff appointed under subsection 1 shall come to an end at the time the President leaves office. 3. The functions of the Chief of Staff to the President shall be: A. To act as the principal advisor to the President on the running of the affairs of the Presidency. B. To administer and manage the President's office, including the coordination of the administration and execution of the activities of that office. C. To protect the interests of the President, including the control of flow of people to the President's office. D. To assist the President in establishing and managing the President's agenda and vision. And E. To perform all other functions assigned to him or her from time to time by the President. 4. The offices constituted under the office of the Chief of Staff to the President shall be public offices. Director of Public Prosecutions. 129. 1. There is established the office of Director of Public Prosecutions, which shall be an office in the public service. 2. The Director of Public Prosecutions shall be appointed by the President on the recommendation of the Public Service Commission, subject to confirmation by the National Assembly. 3. The qualifications for appointment as Director of Public Prosecutions are the same as those for the appointment of a judge of the High Court. 4. Subject to this section, the Director of Public Prosecutions has the power in any criminal matter in which he or she considers it desirable: A. To institute and undertake criminal proceedings against any person before any court in respect of any offence alleged to have been committed by that person. B. To take over and continue any criminal proceedings which have been instituted or undertaken by any other person or authority. C. To discontinue at any stage before judgment is delivered by the court any criminal proceedings instituted or undertaken by himself or herself or any other person or authority. 5. The Director of Public Prosecutions shall not take over and continue or discontinue any private prosecution or prosecution initiated by the Anti-Corruption Commission without the consent of the private prosecutor or the Anti-Corruption Commission, as the case may be, and the court. The Director of Public Prosecutions may direct the Inspector General of Police to investigate any suspicion or allegation of criminal conduct, and the Inspector General of Police shall comply with such direction. 7. The powers of the Director of Public Prosecutions may be exercised in persons or by subordinate officers acting in accordance with general or special instructions given by him. 8. The Director of Public Prosecutions shall not require the consent of any person or authority to initiate criminal proceedings against a person, and, in the exercise of his or her powers, shall not be subject to the control or direction of any other person or authority. 9. The Director of Public Prosecutions shall, in exercising his or her power of prosecution, have regard to the public interest, the interests of the administration of justice, and the need to prevent and avoid abuse of the legal system. 10. The Director of Public Prosecutions may be removed from office on the same grounds and in accordance with the same process as exists in relation to the removal of a judge of the High Court. 11. The Director of Public Prosecutions shall prepare and present an annual report to the National Assembly regarding the exercise of his or her powers, and the report shall include statistics on the number of A. Criminal cases received for purposes of prosecution. B. Prosecutions undertaken and completed. C. Prosecutions undertaken but not completed. D. Prosecutions yet to be commenced. E. Cases in respect of which prosecution was undertaken and discontinued. F. Prosecutions taken over by him or her. And G. Any other cases for which statistical data may be developed to assist the National Assembly in undertaking and having a fuller picture on the trend of criminality in the country. 12. The statistics required under subsection 11 shall each be aggregated according to type of offense. 13. In reviewing and debating the report provided in accordance with subsection 11, the National Assembly shall not give any direction to the Director of Public Prosecutions, but may make recommendations of an administrative or policy nature. Private prosecutions. 130. An act of the National Assembly may make provision for private prosecutions within 12 months of the coming into force of this Constitution. Solicitor General and Legal Secretary. 131.1. There is established the office of Solicitor General and Legal Secretary, which shall be an office in the public service, and the holder of the office shall perform such functions and exercise such powers as may be provided in an act of the National Assembly. 2. The President shall appoint the Solicitor General and Legal Secretary subject to confirmation by the National Assembly. 3. A person is not qualified to be appointed Solicitor General and Legal Secretary or to act in that office unless he or she is qualified to be appointed as a judge of the High Court.